My name is Steve Zelkowitz. My parents, two Holocaust survivors, were born and raised in Częstochowa, Poland. Before the war, Częstochowa had 40,000 Jewish residents, of which only 10% survived the Holocaust. Among those lost were my grandparents, 6 aunts and uncles, and numerous first cousins, whose names I do not and will never know. My father was an officer in the Polish army who survived the German invasion of Poland in 1939 and ultimately was captured, abused, and imprisoned by the Soviets. My mother acquired false papers and lived as a practicing Catholic in Warsaw. They became reacquainted after the war and left Poland in 1946, where they spent 2 years in a displaced persons camp in Germany, a place with many other survivors who had no other place to go. Finally, in 1948, they received permission to emigrate to the United States, and I was born a year later. I am participating in the AJC Global Forum in loving memory of my parents and all those lost in the Holocaust, and may we never, ever forget. I cannot and will not be a bystander while anti-Semitism grows in Europe, the United States, and elsewhere. We must stand tall and proud, speak up, and link arms.
Welcome, everyone, and thank you for joining us today for the hate speech debate. Should free speech be limited? I'm Holly Huffnagle, AJC's U.S. Director for Combating Antisemitism. Hate speech is on the rise. The internet, in particular, is broadly recognized as the largest disseminator of hate speech today, including hatred directed against Jews. As Europe legislates and censors hate speech, the United States defends free speech and the First Amendment. But should free speech be limited? If yes, can governments and private companies be the trusted arbiters in determining what is hateful or anti-Semitic, or what is true and what is false? And if we do not censor, won't hate speech continue to spread? To answer these questions in their own divergent ways are 2 lawyers, true experts in their fields, one from the United States and one from Europe. We are privileged to be joined today by Nadine Strossen, New York Law School professor and past president of the American Civil Liberties Union, the ACLU, who has testified before Congress on constitutional law and civil liberties, and also by Dan Shefet, a French lawyer, the president of the Association for Accountability and Internet Democracy, the AAID, and an expert with the Council of Europe on the Internet Ombudsman. On behalf of AJC, we welcome you to the virtual debate stage. Thank you for being with us today.
Thank you.
I'm going to ask each of you to respond to an opening question in which you will have 2 minutes to answer. And then I will ask you to respond to, or rebut, your counterpart's opening response. We will then engage in several rounds of questioning, which I expect will generate rebuttals. Finally, you will have an opportunity to make your concluding remarks. We anticipate a spirited debate. I just ask that you keep your remarks on topic and on time, and that you remain civil. It is my job to keep time and to referee. Let's begin. Dan, I want to start with you. You have been called a free speech slaying jet setter, and I think we need a more accurate, or at least a more proper introduction. What is your position on free speech? What happened in your personal life to reach those conclusions and propel the work you are doing now?
Well, thanks a lot. That's a fantastic title. I really appreciate that. I don't know really whether I deserve it, though. My quest has not been that of pitting free speech against restricting speech in any way. Actually, what I'm fighting for is accountability. To the extent that accountability means that it will put a limit on certain actions, including speech acts, then I may be imposing certain limits on speech. But my main task is really to make sure that all the actors on the internet are accountable like we teach our children to be. accountable like a basic ethical and philosophical premise on which our societies are founded. That's all I want. And that I really, again, if that pits me against the free speech sometimes, and sometimes it may not, to your big surprise, fine, I can live with that. And I'm pretty sure that Nadine is going to make it clear where we may or may not disagree. But please remember, I'm not against speech, and I'm certainly not against free speech, but I'm for accountability.
Thank you, Dan. Nadine, you are a strong defender of free speech. In fact, your recent book is titled Hate: Why We Should Resist It with Free Speech, Not Censorship. You are also the daughter of a Holocaust survivor and have been asked before, how can you defend free speech for neo-Nazis and other racists? So why should we defend freedom, even for the thought that we hate?
Holly, I love the fact that Dan talked about his quest, because I too have been on a lifelong quest, and it is for human rights to maximally preserve the equality and dignity and freedom of every single one of us, no matter who we are and no matter what we believe. And I am absolutely convinced through my decades of activism, mostly in the United States, but also collaborating with counterparts all over the world, that a robust freedom of speech, robust enough to extend even to ideas that other people brand as hateful or hate speech, that is the essential bedrock for securing and promoting all other human rights. Throughout history, the greatest engine of advancing justice and equality for Jews, for racial minorities, for women, for sexual orientation minorities, anybody who has traditionally been marginalized or disempowered. The single greatest engine for overcoming that inequality is robust freedom of speech. Conversely, the single biggest tool that is used to suppress movements for equality has been censorship, including censorship of so-called hate speech, because that is such an inherently subjective term. It essentially empowers whoever is enforcing it to silence whatever voices they find hateful or disagreeable. After all, why did Martin Luther King write his historic letter from a Birmingham jail? So I certainly share Dan's goals. I just radically disagree that censorship is an effective or appropriate means to promote those goals.
Thank you, Nadine. Dan, I actually want to give you the opportunity to respond to Nadine's opening answer. And maybe actually, can you include in your response back to my initial question about maybe in your personal life, your relationship with Google, and why American citizens are actually reaching out to you now to help them?
Okay, let me explain. I'll address those questions. But let me explain that, I didn't mention the word censorship at all. Nadine did. And I'm glad about Nadine's quest and mine being more or less the same in terms of human rights. I also agree that free speech is a foundational right, but I don't have a hit parade of rights. It's not the top of the right. There are other rights that are at exactly the same level. Dignity, integrity, life, and so on. They are all at the same level. And that, that causes me to say that maybe, Nadine, we do agree on a lot, but when it comes to what seems to me that you are conflating accountability with censorship, you're fighting for the wrong cause. Now, let me tell you about my personal experience, and let me explain precisely what I mean by accountability and what the real risk to free speech is today. I have two stories to tell. And the first one I'll tell you is not the one that you're thinking of. A couple of years ago, I was interviewed by one of the leading press agencies in the world. And that interview had to do with the Google case that you mentioned before. And the interview went live, and the journalist then called me from one of the main offices of this press agency, saying that they just received a phone call from one of the tech companies asking for the article to be modified, to be changed, because they didn't like it. Now that to me is the greatest threat to free speech we have today. Concentration of power in a handful of companies that wield so much power that not only are our politicians afraid of disagreeing with them because they can create and destroy careers, but the free press is no longer free because they're also afraid of them. This is the accountability that I'm looking for. Now, the other personal experience I had, which really put me on which was before the interview that I just mentioned, and I think that the story I just told you is frightening. Because that is what I call corporate censorship, and that's what we have today. And if you ask me what I prefer, corporate censorship or accountability after the fact, enforced by judges, I prefer the latter, not the former.
Dan,
The other experience I had, and I'll get back to what I think was really...
30 seconds, Dan, thank you.
Well, you asked the question, yes, it's true that as a lawyer, what you do is you represent clients. And in one of the cases, I represented a client and won the case. I did my job. Unfortunately, the other guy was a very poor loser. And he fled the country. Actually, he went bankrupt, and afterwards he was in prison for 3 years. And he started attacking my client and everybody who had anything to do with my client, including myself, because I was a really bad guy because I won the case. Arguing all sorts of terrible things, including that I was a member of the Serbian mafia, of course. The fact that he's still alive proves that I was not. So, that was terrible. It was terrible for my family. It was terrible for myself. I understood. I understood what it's like for an individual, this David and Goliath thing, confronted with big corporations that refuse to take down this content in the name of free speech. So I'm all for accountability, and I'm all for free speech in the sense of accountable speech.
Dan, thank you. Nadine, I'm gonna let Nadine jump in here. And Dan had another minute. So Nadine, if you want to take up to 3 minutes to respond to Dan's initial remarks, that would be great. And then if you could also bring in the First Amendment here from the U.S. perspective. We often hear that the First Amendment protects hate speech. That Dan is working to maybe keep people accountable, maybe not to censor, but to that accountability factor. Does it actually protect hate speech, the First Amendment?
We have so many different irons in the fire here now.
Let's go.
Not exactly sure of where the disagreement between Dan and me is, because when you say things like accountability or censorship, we're both for one and against the other, but the devil is in the details, right? So let me start with where I strongly agree with Dan, which is that powerful social media corporations, as a practical matter, have more censorial power even than many governments have, right? Because they have become the dominant medium for the exchange of ideas, not only among people ourselves with friends and family and colleagues, but also in the United States and around the world. But I'll quote the U.S. Constitution, which begins with the words, "We the people." We the people wield sovereign power. But how can we do that unless we can freely exchange ideas and information with and about those who govern us? And yet, as whom we elect to be accountable to us, as the Supreme Court has said, there is absolutely no debate that the most important platforms for that kind of exchange between government officials or candidates to become government officials and the people is on the social media. So if we don't have free exchange of ideas there, for all practical purposes, we don't have it anywhere. And I completely agree with Dan that in some ways the power that the censorial, or at least potentially censorial power that's wielded by these private sector companies is more bothersome than censorial power that's wielded by the government because of this notion of accountability. At least in theory, our government officials are accountable to we the people. But Facebook, Twitter, and so forth, they are accountable only to their shareholders. And in the case of Facebook, that means to one person, Mark Zuckerberg, who holds controlling power. Now, this gets us back to the First Amendment, Holly, because the question is, what tools are available for reining in that power and making sure that it is used consistent with the free speech values that are reflected not only in the First Amendment to the U.S. Constitution, but also in Article 19 of the Universal Declaration of Human Rights and Article 19 of the International Convention on Civil and Political Rights, which has been ratified by 173 out of 195 countries in the world. So I want to make clear that I am advocating not only American values, but truly international human rights, free speech values. What many people don't realize is that the First Amendment directly applies only to government entities. So if Donald Trump issues an executive order, which by the way he has done, that suppresses free speech, one would have a First Amendment right of recourse against him. Indeed, a lawsuit has already been started because of the executive order he issued a few days ago with respect to social media companies. But if the social media companies themselves suppress your speech or say a certain message will be kicked off or a certain speaker will be kicked off, you have no recourse under the First Amendment. And therefore you have to look for other sources of recourse. I think so far, Dan and I are probably on the same page. I suspect where we would disagree is what kinds of steps we would like social media companies to adopt. So I won't attribute.
We'll get there. Yeah, that sounds great, Nadine. We'll get to that point. Thank you. I actually want to take us to the formal round of questioning now. And Nadine, I think I want to stick with you actually to a little bit longer so you can continue the thought that you had.
Thank you.
Yeah, I know I interrupted you. I want to move into our formal round of questionings and rebuttals and get a little bit more back and forth.
And I'm
here.
depending on your interruptions because I'm not looking at the clock. I'm looking at the
Perfect. But I want you to finish what you were saying, go ahead. But then I want to stick to that First Amendment piece because I think it's so critical, this misunderstanding that so many Americans and other global citizens have with our First Amendment. And you were hinting at it with this international human rights law. You know, we know hate speech can cause harm, including psychological and emotional harm to its targets, as well as foster discrimination and violence. We know this, potentially violating human rights, right? So can you assess that out a little bit more? Where does the First Amendment fit in with this international human rights law? Is it really compatible?
Exactly. And it is, but I want to distinguish international human rights law, by which I am referring to UN treaties, the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, and the Convention to End All Racial Discrimination are the most important, as authoritatively construed by the authoritative UN body, namely the UN Human Rights Committee. Those guarantees have been interpreted essentially the same way that, in the same speech protective way that the US Supreme Court has interpreted the First Amendment to the Constitution, which is, to summarize it, a little bit oversimplified, but not much, because it's a very complex body of law. But the basic notion is often described as the emergency principle. Government may suppress speech when necessary to prevent an emergency, that the specific speech directly threatens certain specific, imminent, serious harm, and no method short of suppressing the speech is going to prevent that harm. And specific examples that satisfy that appropriately tough standard are a true threat that intentionally and does put the targeted audience in fear that she is going to be subject to attack, intentional incitement of imminent violence where the violence is likely to happen imminently, targeted bullying or harassment. And those standards really have been adopted by the international human rights concept of free speech. In contrast, we have the law of most other countries, including Canada, and so forth, and regional human rights bodies, including the European Court for Human Rights, that have adopted a much less demanding standard, one that we used to have in the United States until about the middle of the 20th century, which our courts refer to as the bad tendency test. Even speech that doesn't satisfy that demanding emergency standard may still be censored if it might indirectly lead to some negative consequences. And believe me, I totally understand that all kinds of speech that doesn't satisfy the emergency standard can indeed cause psychic harm, might potentially lead to violence down the road, might indirectly foment discrimination. But the reason why the United States and international human rights law say censorship is not the answer in that situation is that government then has, or whoever is enforcing the standard, has too much latitude. Because basically, as Oliver Wendell Holmes put it, a great Supreme Court justice, every idea is an incitement. Truly everything that anybody says, certainly on important and provocative topics such as political topics, might cause somebody harm, might well lead somebody toward violence. So we can't give latitude.
Yes, Dan, I think Holmes' quote is a good way to end. I want you to jump in here, Dan. What can you respond to Nadine on this, maybe this incitement to violence, the First Amendment, protecting of human rights? What do you think, Dan?
With great pleasure. I'm glad, Nadine, that we agreed on a lot. I'm not surprised, but we don't agree on the way that you presented international law on the subject. Your presentation is very much influenced by the First Amendment. You did quote Article 19. Article 19 both of the Universal Declaration and of the ICCPR. But there is also Article 20, Section 2, which explicitly, and that is international law, prohibits advocating of hatred. Now, as you know very well, the US government, when they ratified the ICCPR, reserved their rights not to implement that to the extent it violated the First Amendment. But that is precisely the opposite of what you say. International law reflects a prohibition against advocacy of hatred, and the US is exceptional in not abiding by that. So what you're doing is you're presenting international law as if it was American law. It is the opposite. And I'll give you an example of a concrete example of why you're wrong. In 1996, the French law on negationism, the first in the world, that made it a criminal offense to negate the existence of the Holocaust, was tried before the UN High Commission for Human Rights in Geneva under Section 23 of the ICCPR, which the US did not accept either, which actually means that a signatory state accepts the decisions of that commission. By the way, the US has consistently not accepted such decisions, has not adhered to the International Criminal Court. The only court it has accepted under international law is the International Court of Justice, because it's part of the UN Charter, as you know. Now, in 1996, the court decided that the French law did not violate the Article 19 of the Universal Declaration, Article 19 of the ICCPR, and the president of that court, the former Supreme Court judge in India, Mr. Bhagwati, in a beautiful and very, very well-reasoned majority opinion, explained why, in spite of the fact that free speech is a foundational right, it was not an illegal restriction of free speech to include a prohibition on negation of the Holocaust. So that is what international law says today. And I even go further and say the cases that we had, for instance, on the Rwanda, the special tribunal in Rwanda, the Nahimana case, which is a leading case, also from 94 and 96, actually convicted Nahimana to prison for his infamous incitement to violence and hatred on Radio Mille against the Tutsis. And we have several other cases. We have the Shechel case from the International Criminal Court, which actually arrives at the same conclusion. So international law I'm afraid I disagree. It is not a reflection of the First Amendment the way you described it. It's quite the opposite. Now, in terms of Oliver Wendell Holmes, who seems to be a prophet, who's always quoted when you discuss the First Amendment. I don't know why he's a prophet. You know, I can quote the Bible, and I think that's more important because it says the opposite of him. It actually makes it accountable for what we say. Oliver Wendell Holmes, you know the Buck versus Bell case, which was eugenics, which actually was a defense for non-procreation, for forced non-procreation. And that case, you know, that case was actually quoted in the Nuremberg trials. Your famous prophet, Oliver Wendell Holmes. And you also know very well that in the Schenck case, he took the opposite position of the Abrams case. So I don't know why you keep quoting this prophet if it means anything at all.
Well, Dan, if my standard were that I could not quote anybody unless I absolutely agreed with every single thing that person said, I would not quote myself. So my standard is this particular statement something that is true and relevant? Now, I disagree with so much of what Dan has said, but I don't want to descend into a lot of legalistic points for this audience. Suffice it to say, and thank you for giving me the opportunity to say this, Dan, that Article 20, which does include an express exception of freedom of speech for advocacy of hatred, incitement to hatred or hostility, has been interpreted by the authoritative interpretive body. It's like the Supreme Court for interpreting the ICCPR for all practical purposes, the Human Rights Committee, as requiring that any such restriction on hate speech has to meet the same strict standards that it has laid out for Article 19 in general. And basically, that means that it has to be narrowly tailored and necessary to promote a countervailing important goal. And obviously the goal of reducing hatred and discrimination and violence is of compelling importance. But the difficulty is for government, which has the burden of proof under both articles, to show that the particular restriction is necessary in order to promote that goal. And here's where we get to all of the evidence about how, no matter how well-intended restrictions on hate speech are, they are at best ineffective and at worst counterproductive. And we can go back to Nazi Germany and the history, and we mentioned the Holocaust, my father being condemned to slave labor in the Buchenwald forced labor camp where he almost died. By the way, I think of that infamous Oliver Wendell Holmes statement, which I quote because I like to quote statements that I condemn as well. Buck versus Bell. My father was scheduled to be sterilized by the Nazis as a Jew and also as a political opponent to Hitler. And literally one day before he was going to be sterilized, he was liberated by the U.S. military. So I really owe my life as well as my liberty to the U.S. military. And my passion for human rights stems from my hatred of the Nazis and my absolute conviction that we will never defeat such brutal regimes through censorship. That was attempted to be done in Weimar Germany, which had very strong anti-hate speech laws, which were very strictly enforced according to the leading Jewish organizations of the day. And Julius Streicher and other Nazis who were repeatedly convicted under it loved it. These trials became propaganda platforms for them, where they got a lot of attention and sympathy they otherwise would not have. We look at Germany today, which just has some of the strongest hate speech laws in the world, including on the internet. And yet we have such an explosion of anti-Semitism, anti-Semitic violence that for the first time ever in German history, Angela Merkel 2 years ago had to appoint a cabinet level commissioner for anti-Semitism, where that person, as well as the leader of the coalition of Jewish communities in Germany, had to warn Jews that it's not safe to go outside in public wearing the yarmulke, wearing the kippah. So certainly attempting to stifle hate speech is not an effective way to protect Jews or any other embattled.
Nadine, that's a perfect lead into my next question. Two things. Why? Because I want to get to counter speech and I want to get to what's happening online. Like you mentioned, these increases in online anti-Semitism. You've mentioned that you oppose censoring hate speech, but you've been a strong advocate of something called counter speech. We talked about earlier, what are the steps that we can take? If we can't censor the hate speech, what can we do? You know, we've often been told that it's unfair to expect targets of hate speech to have to bear the burden. Especially since many of them don't have the education or access to technology to effectively engage in counter speech, or maybe they feel intimidated and chilled from speaking. We see this especially online. So how do you respond, and what steps would you support to reduce the harm that hate speech potentially causes? And then please just take only 2 minutes on this, because Dan, I want to get back to you to respond to a whole lot.
Talk to me, Holly, when I get beyond 2 minutes.
Of course. Yeah.
I promise I will. So the term counter speech, which tends to be used by lawyers, really means nothing more or less than any use any of us can make of our freedom of speech to counter ideas of hatred, discrimination, stereotyping, to promote affirmative ideas of equality, dignity, inclusivity, equal human rights. And the range of options for counter speech is literally infinite. I like to think of proactive ways of affirmatively putting out information about groups that people might think of as the other. Social science confirms that the more information they have, and preferably the more opportunity to interact, either in person or even through seeing a media depiction of the other groups that they have feared or had prejudices against, actually goes an extremely long way toward breaking down those misunderstandings. And there are so many studies that have shown the efficacy of that kind of group-wide outreach. There are also amazing testimonials that I find very moving of a more one-on-one kind of interaction, including online, of people, very heroic people in my view, have gone online to deliberately seek out hate mongers, even leaders of hate monger organizations, and have engaged in long, painstaking discussions in which they empathize with the person, not with the ideas, because using a condemnatory, argumentative tone doesn't work, but a more empathetic one does. And there are now famous cases of even longtime leaders of hateful organizations having been, and here's the term they use, having been redeemed by those who engage with them. The internet makes it a lot easier to disseminate hate, but it also makes it a lot easier to counter hate through these various techniques.
Thank you, Nadine. And Dan, I want to turn to you now and give you some time to respond to several of the things Nadine said, but specifically with counter speech. Do you really think counter speech can work when maybe one person might have 80 million followers and that much reach versus someone who maybe only has a few hundred? And also Nadine brought up earlier a German hate speech law. And I want to return back to that because France has recently passed a hate speech law, which actually is coming into effect next month. Can you comment on those two laws? Because critics, like Nadine, have said that they're going to be leading to censorship. Do they? Are they, keeping people from expressing themselves? And how do we know that they won't lead to massive censorship?
Let me just make one comment first on what Nadine said in relation to Article 20, Section 2, which had to do with advocacy of hatred.
Real quick, less technical.
Real quick, it may be a bit technical. The debate here, as Nadine very well knows, stems from a very unfortunate interpretation from the International Law Commission, which is interpretation number 34, which seems to imply causality. In other ways, that the hatred in question has actually led to violence. That may be the test, but in the cases that I just mentioned before, that causality evidence has not been applied. Now, the counter speech. I was surprised that Nadine did not quote her prophet, whom she quotes selectively, Oliver Wendell Holmes, in talking about the marketplace of ideas, because that's usually what is said when you talk about counter speech. Among the many allusions that we hear from advocates of non-accountability is this metaphor of the marketplace of ideas. And actually it wasn't even Oliver Wendell Holmes who coined it. He was inspired, to put it mildly, by Milton, who was inspired by Mill. And the idea is that ideas live their own life, and that it's kind of like Darwinistic, that the strongest idea will prevail. That might have been true once, but is no longer true on the internet, where we live in bubbles. We do not communicate with people that do not share our views. You mentioned like 80 million people. When I look at the groups of some of these social media companies, I see millions of people being in the same bubble and actually only get galvanized into their own prejudice and their own hatred. They never get outside that bubble. And the counter speech, or the metaphor, or the illusion, because that is what it is, of the marketplace of idea, simply, I'm sorry to say, that does not work. I did a lot of work for UNESCO some years ago on radicalization on the internet. Interviewed a number of outstanding psychologists who had actually interviewed some of the people in prison all over the world, including Guantanamo, that had been radicalized. And would you really believe that any of these people were open to counter speech, that they actually listened to anything that took place outside their bubble? Of course not. Of course not. I mean, that is an illusion. And okay, fine. So let me get to the German law. So Nadine, I should have asked you this question. Maybe you want to comment on this afterwards? And I'm sorry to hear about your family. I think we all have stories like that. Do you think that Julius Streicher should not have been hanged? The guy behind the Stürmer? I'll let you answer that afterwards. What you're saying is that the German law under the Weimar Republic and the German law that we have now, the way you present it is as if they have kind of like created anti-Semitism and created the division. Of course they haven't. I mean, we go to hospital because we are sick. It's not because we have hospitals that we get sick. I mean, it's really, the chicken and the egg. Of course, in Germany, what they have now, as the first country in the world, is a hate speech law because of their terrible history. And they're very well aware of that. And they react immediately to that. And I feel that we should all accept that they live up to their accountability. They really do. But to create a cause and effect, inverse cause and effect kind of correlation between those laws and the prevalence of hatred, I'm sorry, that really doesn't make sense to me. So the German law, which entered into effect a couple of years ago, and I'm actually working together with some people from the Ministry of Justice in Germany on a comparative analysis of the German law and the French law, which will most probably enter into effect, as you say, on the 1st of July, are laws that apply to the internet. And that is in recognition of the fact, the undisputable fact, that there is a lot of hatred on the internet. And another undisputable fact, which is this illusion of saying, okay, why don't you just sue the author of that hatred and then he will take it down? Of course you can't. First of all, many of these people are complete psychos, and they wouldn't care about the fines or prison or anything like that. Second, you can't find them. And third, it'll take much too long and people will die in the meantime. All you can do in order, if you want to do something, in order to stop this curse that we have right now, which is unrestrained dissemination of hatred on the internet, is to put a certain accountability on the gatekeepers. Now, gatekeeper accountability is certainly not the first time in history that we have. And this is, again, in full line with my personal philosophy and also what we see reflected in both the German and the French law. Once the gatekeepers, in this particular case, the tech community, are put on notice in different ways or have actual knowledge, that's sort of the technical term, of the harm that is being disseminated on their pipes. Then if they continue not to take action, they become accountable.
Dan, thank you. Nadine, I want to go back to you. You can respond to Dan's question, but also, does his argument hold water? You know, can these laws do more harm than good? He was right when we know that the violence that is on, you know, the incitement to violence online or just even hate speech online does have real world consequences. We saw this in Pittsburgh, in Poway, in Christchurch. You know, we know this. So how do we deal with the online companies?
Well, I resist that when you say, and it's interesting because I thought Dan was also questioning the causality. The fact that somebody says something hateful and then they commit a violent act does not mean that there is a causal impact. There are a lot of situations where people just mouth off vile things and do not engage in hateful conduct, or the opposite, where they don't say anything and they engage in vile conduct. So for me, the goal is, how do we reduce two things? Number one, hateful, discriminatory ideas, and number two, hateful, discriminatory conduct, including violent conduct. And I think it is a waste of time to go after rhetoric that does not satisfy the strict emergency standard. And some of the examples that Dan gave do satisfy that standard. Rwanda being the prime example, but also Julius Streicher. Of course, that was intentional incitement to imminent violence, which did in fact occur. And in the case of Rwanda, it was actually providing material support, information, for example, about where some of the targeted individuals were hiding. Of course, that is appropriate. So I think it's wrong to get off into this all or nothing, that under the American view, under the international human rights view, all expression is absolutely protected. No, when there is that tight, direct causal connection to violence, then and only then, censor it. But beyond that, I think it is so interesting that when you look at all of the European countries that have in place very strict anti-hate speech laws that allow censorship because of the looser bad tendency that the speech might lead somebody to engage in violent conduct, which, by the way, there's no work in the world that has not been credibly blamed for causing me to engage in violence, the Bible and the Quran being prime examples. So if we had that standard, basically everything would be subject to suppression. But let me give you an example. The European, CERD, the Commission for the Elimination of Racial Discrimination, which enforces anti-discrimination laws, including hate speech laws throughout Europe, in its most recent report, talked about the ineffectiveness of these laws in actually quelling problems of discriminatory attitudes and actions, and said, and this is an exact quote, counter speech is much more likely to be effective, much more likely to be effective than censorship. So we can put aside legalistic standards in terms of what is likely to work. Even the European bodies are veering in support of counter speech.
Nadine, thank you. I'm actually going to stick with you for one more question, then I'm going to turn it to Dan for him to respond to what you just said, and then we're going to probably begin to move into our closing comments. I want to get back to free speech. So let's put hate speech aside for a second. Just because of the United States, the First Amendment, this is the big issue on if free speech should be limited, even not including hate speech. I'm going to ask you this, Nadine, and then I want Dan to respond. In the United States, as we know, there is no state regulation towards social media platforms, right? Although states do not regulate, the U.S. National Security Agency does collect swaths of data on users from their data center in Utah. Now, do you consider that this surveillance already presents a kind of regulation of free speech?
Absolutely. And surveillance of data by private companies is something that should be illegal in the United States. All advocates of cyber liberties and civil liberties have been clamoring for years, lobbying for some kind of meaningful data protection. Going back to long before 9/11, because I remember before the terrorist attacks, there was widespread bipartisan consensus on finally passing the kind of privacy protection that hats off to Dan and my other friends in Europe. You've done a much better job than we have, an infinitely better job than we have in data protection. And the reason I link this to 9/11 is then after the terrorist attack, the primary concern became national security, and every attempt to protect privacy went down the drain because it was seen as somehow potentially interfering with national security counterterrorism efforts. And to make matters worse, the National Security Agency abused its anti-terrorism power to engage in massive data gathering about innocent Americans all over the country. This is what Edward Snowden's revelations revealed, and we still, the American Civil Liberties Union, Electronic Frontier Foundation, other human rights agencies and organizations have tried through the courts, we've tried through Congress to protect meaningful privacy. We still have not succeeded.
Thank you, Nadine. And Dan, I'm going to turn this kind of last question to you. I want you to respond to some of the things that Nadine has said. You might agree with some of them. And I'm going to actually stick with a United States law to you as well to get a European perspective. We're going to talk about Section 230 of the United States Communications Decency Act, which for our audience is a 1996 law that keeps online platforms from being held liable for most content posted by users. And many Europeans will say that's quite problematic. Dan, you of course have been arguing that these companies should be responsible, they should be liable for what is on their platform. It was alluded to earlier, but just recently, President Trump accused Twitter of stifling free speech and interfering in the 2020 election because Twitter fact-checked one of his tweets on the issue of voting by mail. President Trump then signed a new executive order, which seeks to limit Section 230 of the Communications Decency Act, but maybe not how you or your European counterparts expected that would happen or wanted that to happen. So Dan, could you please give us some insights on how the Europeans are viewing this?
Let me first address some of the points that Nadine made. I'll be quick on that, and then I'll get back to the executive order that you mentioned. It's not that I have a problem with establishing a causality or correlation, Nadine, not at all. I've actually very strongly argued for that in terms of especially fake news laws, which I'm strongly against. I could quote probably just as many or even more reports by psychologists and sociologists proving that there is a link, a correlation, a causality behind hate speech and incitement to violation, and then the act of violence. It's of course a debate that goes back to the 60s in terms of TV. We also had it in subliminal advertising. We had it in terms of video games, and now we have it again. So just to balance this presentation, you mentioned the European Commission study. I could mention lots of others that showed that there is such a correlation. And it really shouldn't surprise us. It shouldn't surprise us at all, because it's the business model of these companies to persuade us, to nudge us, to not only to buy products. And why do you suddenly believe that this whole business model, which is based on advertising, which is really accepting that we can be manipulated, because I use that very strong word, in order to choose one product over the other, why do you believe that has no effect on our behavior? Of course it has. It would be like challenging the whole business model of the internet, saying the opposite. And that brings me to the remarks on the CDA, because that is precisely the problem we have today. The problem is not the First Amendment. The problem is the immunity. And that gets back to my first point, accountability. Accountability and immunity simply are contradictions. And by giving social media and search engines and so on and so forth this complete immunity, you make them unaccountable. That to me simply no longer works. Now, in terms of the executive order, it is very interesting. We in Europe, and me especially, have of course been studying this, and without voicing any political views, because they have nothing to do with the case that I want to make, because I'm speaking as a lawyer. It's really in two sections. The latter part is instructions to certain government agencies, including the FTC and so on, to audit and so on what's going on, and this is of course Twitter. The first part, from a legal point of view, is very interesting. Because what the White House, actually what they say here, and again, don't take this as a sign of me agreeing, I'm just speaking as a lawyer. what they actually say is that there is a difference between the first section of 230C, which talks about absolute immunity, and the second section, which talks about what we call the Samaritan Clause, which means that if a search engine or social media actually interferes somehow in content, well, the threat was, the concern was that somehow doing the right thing could make them vulnerable to civil or penal responsibility. And that's why in the CDA, Section 2 was entered, saying that, okay, we won't hold you responsible if you delete something or if you modify something, you are still immune. But the difference between Section 1 and Section 2, and here the White House is right from a matter of law, is that Section 2 has a condition of good faith. In other words, the absolute blanket immunity that social media and search engines have under the CDA for content is absolute. They are not editors or publishers. But if they start interfering or intervening in the content, then there is a good faith condition. And the point that is made by this executive order is that it is not done in good faith when it has the purpose of interfering in democratic elections only against one candidate. Now, you may discuss that or not discuss that. I'm only pointing out what the law is here. And on that particular point, reading the CDA, reading what it says, and again, I don't agree that we should have the CDA at all today, because that makes the internet not accountable. But reading what the law says, I think they have a point.
Thank you, Dan. Sorry. I appreciate your analysis from a European perspective. And I actually want to, in our last couple of minutes here, really kind of wrap up this conversation. And Nadine, I want, if you can, respond to what Dan said with the executive order. But maybe more importantly, instead of talking about what's happening and disagreeing on how, we can actually talk about what needs to happen next from a policy perspective. Like, we're here now. Where do we go from here? Is there hope? What can be done? If you can, in your concluding, final minute or so, just give us a next step perspective, that would be wonderful. Nadine, to you, please.
Okay, so obviously I am being censored. And what I can say, I'm saying that with a smile because of time, about Section 230, which I think on balance does far more.
30 more seconds. I'll give you an extra 30 seconds.
Imagine if we had the social media platforms serving the strict gatekeeper function that in the United States, the traditional broadcast media did. Then basically they would be a platform for the extremely few. The good that has come from the social media platforms, the opening up to previously excluded and marginalized and overlooked voices would not exist. And I think of movements that are, it's so easy for us to concentrate on ugly, horrific expressions online, but let us not forget the positive movements that have become possible only because of the availability to anyone of this cheap worldwide medium. The whole Black Lives Matter movement really would not have gotten traction without it. And then we see the importance, sadly, of that at this very moment, this very week. The Me Too movement and movement, time enough against misogynistic violence really depended on social media. It's also true that in the United States, we've had just an absolute flourishing of political candidacies and successful ones, including at the national level of government, of young people, minority people, immigrants, women, religious minorities who never could have gotten their campaigns off the ground if they had to depend on the small number of highly kept traditional broadcast media. So, let's not throw out the baby with the bathwater here. Let's celebrate the positive, empowering, liberating, equalizing potential of the internet, including social media, and figure out ways to harness those positive aspects without unduly allowing flourishing of the negative aspects. And to this, I would say, Holly, that I'm so encouraged by studies that are being done by universities, by foundations, by think tanks about exactly this. How can we make best use of the unprecedented power of the internet and social media to advance positive ideas and to empower individual end users and families to set in place their own blocking and filtering mechanisms. That was the original goal of Section 230, which had enormous bipartisan support in Congress. The goal was to make it possible for every end user to choose from a panoply of filters and blocking devices what expression they would choose to see and not choose to see. So these are the positive pro-education. And by the way, I should say, since we're speaking to the American Jewish Committee, that the Anti-Defamation League and the AJC and other Jewish organizations have worked very closely to harness the power of the internet to steer would-be Holocaust deniers and anti-Semites toward positive information, including their own websites and that of the Simon Wiesenthal Center, the Holocaust Museum, and so forth.
Thank you, Nadine. I appreciate that. And Dan, I want to give you the last word in just the last couple of minutes. Any final points you would like to make? And maybe from your perspective, what policies need to happen next? Where do we go from here?
Well, first of all, obviously, I agree. How could I disagree that that social media have done a lot of good? And the examples that you mentioned, Nadine, of the Me Too, the Black Lives. I mean, how could anybody disagree with that? I think the purpose of this discussion is when things go wrong, when this discussion deals with hate speech, not the good things about the internet. I'd like to make I realize that, Nadine, you didn't answer my question whether you feel it's right that you have no legal redress against the company.
You would. You absolutely would. I'm so sorry. Section 230 does have a couple of exceptions. One is for federal criminal law.
Yeah, but this would not be federal criminal law. This would simply be incitement to hatred.
There's a federal criminal law against that, Dan.
Okay, so you have censorship.
I said consistent with the emergency principles, speech could indeed be suppressed.
So what I think is that kind of censorship should be left to the judges to decide. Now, the point that I also want to make on speech is that if you analyze the notion, the philosophical notion of free speech, you really have to make many distinctions, but you at least have to make the following distinction. It's what I call vertical and horizontal speech. Nobody, and especially not yours truly, is going to dispute or going to accept any limitation of what I call vertical free speech, which is speech against those that wield power. Now, that could be government, public figures, corporations, or whatever they are. Any entity or person that wields power over you or over a group, there should be no limits as to what you can do because they wield power over you, and the only power that you have is your free speech. What we're talking about here is not that at all. We're talking about what I call horizontal free speech, which is really a completely different animal. It shouldn't even be called the same thing. This is the right for an individual to destroy the life of another individual. And this other individual holds no power, no sway over the first. These two things are completely different. And unfortunately, the arguments in favor of the latter are very often taken from the former. This is what I call a categorical mistake. It's a logical fallacy. So what I would like to see happening is that the CDA, which probably was the right thing in 1996, and we're 25 years down the road, which in terms of technology is like 100 years, needs to be severely revisited, just like we're doing it in Europe. In Europe, we've had the e-commerce directive now since year 2000, and we are now revisiting that. We have a test in Europe. For Europe, when I say Europe, it's the European Commission, which says that once you have actual knowledge of harm, you have to assume responsibility of continuing that harm. And what we will probably be doing in Europe is devise a third category, because we have what we call mere conduits, which is hosts, which is the kind of stuff that we had back in the in the 1996. And these, now we of course have companies that do a lot of other things, which is like culling information, which is distributing information which they have selected. And these are the social media, these are the search engines. And actually, to a certain extent, they make money on that information. If a company would actually have an economic interest in disseminating hate speech because it attracts attention, we all know that they make money on attracting attention. And we all know that when it comes to attracting attention, there's only sex that's stronger than hate speech. If companies actually make money on this kind of stuff, they should be responsible. And the advertisers should also be. So what I would like to see is a clear distinction between vertical and horizontal speech. I would like to see that the CDA be reformed in such a way that it would not be against accountability, that it would allow class actions, civil suits, and the rest of it for the judiciary to decide, like any other court case, like any other industry. Why should they be immune? The only industry, why should they be immune? I don't see any reason for that. And this immunity, unfortunately, does not promote the kind of good stuff that Nadine rightly mentions, but the bad stuff. Because once you're immune, you're immune.
But once you're not immune, you're not immune.
Why should you take
A lot of
steps?
us wouldn't be allowed, right?
Why should you take any steps to stop what attracts people's attention if you make money on that?
I don't want to close this debate because I know we can keep going. In fact, I know Nadine already has an argument, Dan, to what you just said, but we are, yes, I was going to say to be continued. We didn't even get to artificial intelligence or content takedown that's misappropriated. Like, how do we, deal with that? So there's just so much more conversation to be had, but we are officially out of time. We are officially over time, but quite a thought-provoking and powerful debate. And really at this point, I just want to thank our debaters, Nadine Strossen and Dan Shefet, for your time, your persuasive arguments, but also for your thoughtful exchange. AJC will continue to tackle these tough issues, and we are appreciative of our relationship and our partnership with you both. Thank you.
And Dan, here's a virtual handshake. Thank you, Holly.
Thank you.
Hello, I'm Harriet Schleifer, president of AJC. Every June, we come together at AJC Global Forum. Being there, we're at the center of the most important conversations affecting the Jewish people in our world. This year, the pandemic changed everything. AJC responded by bringing the world to you. Thank you for inviting us into your homes. Your commitment to the issues discussed here today is critical. Please consider making a donation to AJC. Together, we can do even more to fight anti-Semitism and hate, stand up for Israel, and defend the values that unite us all. To donate, please visit ajc.org/give. Thank you.